Is it would become CSRI, the CSRI Conference, and the Journal of Issues in Intercollegiate Athletics were fittingly sketched out on some drink napkins at a bar near where the women's basketball championships were being held. About a year later, we hosted the first CSRI conference at the FedEx Institute of Technology on the campus of the University of Memphis. Shortly thereafter, GIA published its first article entitled Intercollegiate Athletics, a preliminary study examining the opinions on the impact of academic performance rate by Keith Christie, Chad Seafried, and Donna Pastore. CSRI, the conference, the journal, and the institute is the result of the efforts of many more people than I have the time to recognize this morning. But I want to thank several people, including my partner, Deb Southall, my daughter, Dr. Crystal Southall, Mark Nagel, Ellen Starowski, Billy Hawkins, Fritz Polite, Alan Sack, Amanda Polikoba, Dave Ridpath, Katie Otto, Chad Seafried, Joseph Cooper, Thomas Aker, Victor Kidd, Matt Brown, Robert Turner, Chris Core, Rick Johnson, Woody Eckerd, Peter Hahn, KB Baluli, Sonny and Pam Vaccaro, Mr. Bill Friday, as well as my colleagues at the universities of Memphis, UNC Chapel Hill, and here at South Carolina. In addition, I want to recognize the many keynote speakers and panelists and the literally thousands of faculty, researchers, and students who have attended this conference. I want to recognize the current and past GIA editorial board members and editors, as well as the authors who have seen fit to publish their research in the journal. They've helped GIA become a highly regarded journal and the go-to college sport research outlet. Finally, I want to give special recognition to Kim Boone, who has almost single-handedly transitioned this year's conference into a 100% virtual event. She's worked tirelessly learning new technologies and building out a great platform through which to share your research and provide today's outstanding live streamed program. I'm humbled to work with her. In the past few weeks, as I went and looked through all the conference programs since 2008, a singular truth came into focus for me. Through the worst of times, in an age of foolishness and during many seasons of darkness and winters of despair, you have helped this conference thrive during the best of times, become an age of wisdom and an epoch of belief, a season of light and a spring of hope. With this in mind, while I want to welcome you to this year's conference, I'm not going to lie, I'm really looking forward to next spring and welcoming each of you to Columbia. First drinks on us. So in an homage to Robin Williams, good morning, CSRI.
Morning, everyone. My name is Rick Johnson, and I'm a Cleveland attorney. Richard has asked me to moderate and be a panel member for today's program, this morning's program, which is entitled College Athletes Name, Image, and Likeness, with a catchy title, What, Why, When, How. I'd like to introduce Mark Edelman, who's a professor at Baruch College. He's a law professor, as well as an adjunct at Fordham Law School, former Skadden Arps attorney, and like myself, has an interest in legal ethics, and he directs the Legal Ethics Center at the Zicklin Center. Rick Karcher, I first got to know as an expert when I did the Andrew Oliver case, and Rick Karcher invented the methodology for pricing college athletes. It didn't exist before then in terms of a litigation damages model. That's how I met Rick to begin with. And the only person who's more opinionated than I am is Rick, which is one of the reasons we get along so well. He's a professor at Eastern Michigan and has written some fantastic law review pieces, just as Mark has, and I'm sure during our discussion they'll mention them. But in any case, the name, image, and likeness is as of the moment, so to speak. Mark, why is it as of the moment? And that kind of, let's start off with just kind of an overview, because so many people misunderstand college sports and what the issues are. Most people just care about their teams and their fans, but in terms of why is it what I would call a civil rights issue now? Can you speak to that?
Yeah, that's a great question. I appreciate it. First, it really should not be an issue of the moment, in the sense that I wrote my law student note on college athlete name, image, and likeness in 2002, 20 years ago. And I was far from the first person to write on this topic. I had plenty to cite. So the notion that college athletes should be able to control their name, image, and likeness has existed for well over a generation. It really has begun to come to the boiling point over the past year or two. And I think it's a confluence of a host of different factors. One of them is the pure revenues that are generated from college sports, and especially football and basketball. We are looking at an $11 billion enterprise to $13 billion enterprise in the NCAA. You have coaches that are making between $8 and $10 million per year, and coaches who are making millions of dollars from endorsing products. So the first distinction, if you want to talk about a civil rights distinction you have here, is the collusive arrangement that prevents college athletes at any school from capitalizing on the name, image, and likeness has made a select few very wealthy and kept the others poor. In terms of civil rights, there's a secondary factor that goes on here as well, which some people may refer to as a reverse Robin Hood factor of giving to the poor and giving to the wealthy. Disproportionately, football and basketball players at college sports are African American and low-income families. And they are the ones who are generating revenue from the enterprise itself. To the extent that any of the money that they make stays within the college sports enterprise and isn't simply given to other areas, including athletic directors, coaches, and presidents, it gets shifted to certain other sports. And those sports where that money gets shifted to include sports such as fencing, golf, most lately equestrian, which is the newest addition, which are sports where the opportunity not only do not generate revenue, but disproportionately are played by individuals who are white and from high income. So I think those factors combine to give notion of a civil rights concern that arises out of what's a concerted restraint of trade against college athletes.
And not to belabor this before I switch to Rick, but is it the civil rights context that makes this of the moment? Because the money and the lack of equity and all those factors have existed for a long time. Is it really sort of an American consciousness that's waking up to Black Lives Matter, that's waking up to the Me Too movement? Are people, and because in football and basketball in the Power Five, the players are predominantly Black and they are the ones earning the money, is this part of the larger social awakening, do you believe?
I really believe it's a confluence of a lot of different factors. And one of the most interesting things to me in terms of college athlete name, image, and likeness rights and removing this restraint of trade, where all of the NCAA member colleges get together and they agree to boycott or ban any school that allows athletes to endorse products. I think it's interesting in that there is something here that's very attractive to the left. And there's something here that's very attractive to the most woke rungs of society. But there's also something here that's attractive to the conservative right. I think those who are looking at the issue from a left-leaning perspective are very much able to see the inequity with race, are very much able to tie this in with George Floyd and Black Lives Matter, are very much able to tie this in with Taylor Branch, I almost said Taylor Swift, referring it to it as having a whiff of a plantation and looking at it that way. And noting the hypocrisy that even higher education, which comes from this ivory tower of historically being very left, are not practicing what they preach. But there is something in here as well that should be attractive to the right. And there's something in here as well that should be attractive to those who are not necessarily walking around with the Black Lives Matter hashtag and are not necessarily woke on human rights issues or Black Rights Matters. And what's going on here is the restraint that prevents college athletes from marketing a name, image, and likeness is a concerted restraint of trade that goes against capitalism, that violates the free market of each individual member school to agree to policies with their own athletes and each athlete to compete in the free market. So I do think there definitely is a very real left-leaning argument here, but there also is, from a more right-leaning perspective, something very attractive about restoring free markets. And I think the confluence of the two together has created this amazing thing where in society right now, where we've never been more divided on political issues, you're able to get people on the left like Cory Booker, and people that are former Trump appointees like former AG Del Rahim, and they look at this issue the same way. And I think there's a real unifying force about college athlete name, image, and likeness rights that are coming both from the left, but also from the mainstream and the right segments of society. And I think that's a good thing.
That's interesting, and that gets exactly to what I wanted to. Rick, what's your view, having listened to Mark? What's your view of, first of all, why is name, image, and likeness in all the newspapers and magazine articles? Why is it constantly coming up in web searches? Why are people talking about it now? This has been an issue for a long time. Why is it of the moment, in your opinion?
Before I try to answer that question, I'm going to address the first part, which you mentioned, which is, after listening to Mark there, I just want to raise a couple points. I don't completely disagree with Mark in anything he said. Just want to clarify a couple things. One of the things he said was revenue in football, or revenue with football and basketball players. First of all, I'd like to think of it more, not in terms of revenue, but in terms of profit. And if you look at purely profit, after they've paid their coaches, as Mark says, after they've paid all of their expenses, after they've paid for all of their lavish facilities, there's still in the Power 5 conferences, and that's the second clarification I want to make to what Mark said. We have to think about this commercial exploitation of athletes in the context of Power 5 conference and primarily football players, because the profit far exceeds in football the profit that is made in Power 5 men's basketball. There's no profit made in any other sport. They all operate at a loss, okay, including women's basketball, even in the Power 5. So when we look at the profit in football in the Power 5, you're talking about self-reported numbers by institutions. So it's probably a little bit higher than that with regards to football, of anywhere from 25 million to 46 million per year in profit. Big Ten makes the most in football, mid 40s. At the low end, you have the ACC, somewhere around 20 million or something. And so, when we talk about the NIL issue, I think it's important not to confuse that with the exploitation that takes place in football. This NIL issue doesn't solve that problem. The NIL issue gives all athletes in all sports some sort of, to the extent we can come to some sort of framework for what it would look like, which we need to talk about within the next 45 minutes. But to the extent there's some framework for name, image, and likeness rights, it's not going to come from the schools, because nobody wants it to come from the schools. Okay, they want it to come from third parties. And so the athletes that are going to be compensated with this mechanism in the context of licensing are going to be primarily star athletes and those who are able to market themselves effectively. And how much are we talking about per athlete? Who knows? Typically, when you start talking about sponsorship and licensing, there's a limited pool of dollars that's available in any context. And so there's going to be a limited pool of dollars that's available for college athletes, and they will be competing against each other for that pool of money. And if you look at Power 5 football, the number of players who have a starting position on a Power 5 football team, okay, many of them cannot generate significant amounts of NIL money on an annual basis. Okay, so I don't view the NIL issue, never have viewed it as addressing the commercial exploitation or the inequities from an economic standpoint in college sports. And as Mark said, I'm with Mark. We've been talking about NIL back when Tim Tebow's off of Tim Tebow, we said, hey, let this guy sell his jersey. Go ahead, Rick.
So I hear you differentiating player equity, and especially Power 5 player equity, and even more specifically, the football players supporting the majority of the program. I understand that, and NIL being kind of a fake fill-in for that problem. But as a larger issue, whether we limited it to NIL or we include player equity, why do you believe that there seems to be a greater consciousness today about these issues among the public, and that the public seems to care a lot more about this than they did a couple of years ago? Because it does seem of the moment to me, and either you agree it is or isn't, but if you think it is of the moment, why, just as a cultural phenomenon, do you believe that this is coming to the forefront?
Well, I think players have started to talk about it themselves. They've started to be more vocal. They never used to be vocal about anything. And so we've seen that gradually through the years. There seems to be this sense, and I don't agree with it, that players, or that all athletes, many people feel that athletes are not entitled to compensation from their schools. And so this is something that people can latch onto and say, oh, well, if they have that right, it just seems like a total injustice that they can't make money from third parties. So we're not even saying from the schools. They can't make money from third parties, and that just tends to rub people the wrong way when what they would be doing is the same thing that the schools are doing in the context of licensing, right? Whether schools get paid by Nike, why can't athletes get paid by Nike? So it lends itself into a sort of a more of an emotional, I think, attachment to it,
So we have a question from our audience that goes right to the point you were just making, which, and the question, I'll read it, is the NIL discussion then a straw man intended to distract from the larger profit center?
Yes.
Mark, what do you think about that?
Maybe. I think that question could be taken in two different ways. And I think the yes component, where Rick and I will agree, is I look at this as a classically trained antitrust lawyer. So it makes no difference if it's 1,200 member colleges or the Big Five member colleges getting together, forming an association and restraining college athlete compensation to zero, or restraining their access to nil to zero. Both activities under classic antitrust law should be seen as restraints of trade, and both would be problematic. So in that sense, yes, it's obscuring from. On the other hand, though, the NCAA has run around for as long as they've been messaging. And remember, the NCAA is really just a collection of member schools. And their argument has always been, if we pay the athletes directly, we're going to lose money. Now, that's probably a baloney argument for about 64 schools. You guys know that. I know that. But if you accepted that as being true for just a second, even the NCAA's historic arguments would not address the nil issue, would not address free markets for nil. And even if we accepted the NCAA's notion of somehow this is amateurism and somehow people like this because the athletes are not paid, and we know that's not true, and we know there are studies that show from the Alston case it's not true, but even if we accept that as being true for a moment too, it still doesn't address nil. So to me, nil is the low-hanging fruit within a broader issue.
Well, if we look at this as profit, Rick, and let's take Ohio State, for instance, where there's reportedly, in addition to the football coach, 10 to 12 assistant coaches earning over $1 million. That coaching staff overhead is vastly in excess of what the Cleveland Browns are. So if we call this profit and we use the manipulated numbers that the universities use, and I say manipulated because we have a distorted labor market. In the NFL, they're paying 50% or so of the gross revenue to the players. In college football, they're paying zero. So when you have a distorted labor market where you have no labor costs for the players, there's necessarily more money to throw around to the coaches. So if we were to accept as legitimate the salaries, for instance, for Ohio State football, rather than saying that those are inflated artificially by 75%, we decrease the profitability, for instance, of Ohio State football. And if we, for the grants and aid to the 85 football players at Ohio State that they charge list price for, if we price those at zero because the marginal cost for the players to so-called educate the players is zero, we end up with an incredibly more profitable enterprise than they're admitting. Can you comment on that, Rick?
I agree with you, Rick. When I started talking about the profit, I said, and these are self-reported numbers, so it's higher. It's actually more than what they're reporting for the reasons that you just said. The athletic department will report that they have expenses equal to a full grant and aid for each of the 85 football players on their roster. Okay, and that's how they're going to report it. But for the reasons that you mentioned, that's not entirely accurate. There's not an expenditure of a full grant and aid. It's a waiver of an obligation of a student to pay the tuition, room and board. It's not the full cost of an expenditure of a grant and aid in terms of if you're thinking about it from an accounting standpoint. But I don't want to debate that. There's no debate that we're talking about here. Huge profits in football, and people don't want to talk about it. They want to talk about all of the total, think about college athletes as a whole, and talk about how there's injustice and how which isn't true from an economic standpoint. The other sports are not exploited. Men's basketball is a little bit, but not nearly as much as the Power 5 football players. So I don't know if I'm answering your question, but you and I are in agreement with each other on this. One thing I want to talk about though with Mark is that he said that it seems like a unified front on this in Congress, for example. He said that there's a unified front, it seems, with Democrats and Republicans, and I'm not really seeing that. I'm seeing different bills that are coming out that are not showing a unified front. We are seeing state laws being introduced that are not the same. Some respects they're similar, and you know, there, so I don't think that there is a unified front on this. Many people want to restrict
I
it.
don't think Mark said that there was a unified front. I think what he was getting at is that when I was asking why this was of the moment to him, I think what he was getting at is that there's issues to excite people on the left as well as on the right. It doesn't necessarily mean that they're going to approach the solution the same, but that they're both interested in getting some sort of a result. And you're absolutely correct, Rick, that there is not a unified front between liberals and conservatives on how they're going to approach it. But it is unusual when each side of the spectrum both says we need to change something. That's remarkable because it doesn't happen often that way. But when it does, you usually get some level of change. And the bills are all across the spectrum, depending upon who's proposing them and so on. So I don't think Mark meant to say there was a unified front. I think he just meant to say that there seems to be a constellation of interest
I got you.
across the spectrum about this. And I've certainly noticed that no matter, and I've also noticed, that at cocktail parties or to the extent that we have these anymore, and of course I'm thinking pre-pandemic, those of us who are knowledgeable in this area can peg our discussion with somebody once we realize where they're coming from. So there's not so many issues out there where pretty much it's a good conversation topic with almost anybody, as long as you peg it to what they're interested in. But in any case, we have two questions from the audience. Let me read the first one, and because it's somewhat interesting. How do you foresee the changes to NIL, assuming there are changes, affecting NCAA booster regulations? And will this create a loophole to ignore impermissible recruiting activities and impermissible extra benefits? And I guess I'll ask that to Mark with the preface that I, of course, think that, and I'm sure he does, that just using the term impermissible recruiting activities and impermissible benefits is all part of the antitrust violation.
I think you just spoke for me beautifully here. My first response, and it's a wonderful question, so I mean no disrespect to the question, it's a wonderful, wonderful question. My very broad theoretical question back is, who cares? We've all been taught to care by the NCAA, but I mean that seriously, why does it really matter? If we go back to the original creation of the NCAA rules in 1906, when the association was first chartered, the original notion of not allowing compensation to college athletes was not about money. The original notion was a very sound notion here, that we wanted to make sure the opportunities of college sports, before they were big time revenue generating, went to the students who actually attended the schools. So the idea is, just like any different school activity, if there are a limited number of opportunities for something, it should go to people who are students there. You shouldn't be bringing ringers who are not actually part of the student body. So there is a very limited aspect of the NCAA rules that I think make sense, that are rules that need to exist to create this structure of college sport as opposed to just sport. I think it's fair because these are teams that are operated through colleges, that if you're going to compete, you need to be attending the college. And I think in good faith, the notion of attending a college should mean taking a certain number of classes and earning some form of a GPA.
So let me interject a quick question, then we have a follow-up on this that I'm going to direct to Rick. But in terms of the word ringer that you use, which resonates with me, not just because it makes sound, but at what graduation level for a team does the team become a de facto ringer? So if for instance, you have a basketball team that has a graduation rate under 50%, are those really college athletes, or are they 60% ringers? Can you answer that concisely for me? And then I'm going to move on to Rick with his follow-up question.
I can't answer it concisely because I think the question has to be, what is the intent at the point in enrollment? If people are going there with the intent to earn the degree, I think the answer is no. If you're putting them in there with a year with the intent that they are going to leave or create an environment that they will leave, where they are not taking classes and not earning grades and not moving towards a degree, then I think they are ringers.
And thank you for that, Mark. So Rick, as a follow-up to the question that was asked, we have a follow-up question. It says, what parts of the recruiting process might be affected or need to be safeguarded, particularly regarding Mr. Karcher's, of course, too much formality there, but Mr. Karcher's point about quote unquote marketability of athletes, and taking into account that you and I share the view with Mark that much of these rules violate the antitrust laws to begin with. Can you speak to that question from the audience?
Sure. I don't care about antitrust, to be honest with you. My view on this, and we could talk about antitrust if you want to, but it's really simple. You know, when we talk about boosters or safeguards or guardrails or however you want to refer to it, any concern about boosters comes from the idea that there's money being exchanged that's not transparent. So, you know, whether you think about it in the context of, you know, the SMU, you know, however you want to think about boosters paying players, there's nothing inherently wrong with boosters paying players in a transaction that's transparent. To the extent that the NCAA believes that boosters paying players is inherently wrong, well, I just completely reject that. There's nothing wrong with apparently boosters paying for, you know, coaches' apartments and boosters saying, you know, that I want this amount of money that I'm going to give you to go pay this coach's salary or whatever. So there's nothing, in my view, that any argument could be made that a transparent transaction with an athlete for their name, image, and likeness is somehow a problem. So, you know, as far as guardrails, directly answering the question, I think the guardrail issue is overblown, quite frankly. I don't, you know, Chris Murphy, Senator Chris Murphy has a bill, his name, image, and likeness bill, which I believe to be the best one that's been proposed, does not have these so-called guardrails like many of the other bills do. Restraints, guardrails is a code for restraints. Yes.
Mm-hmm.
To both of you, we have another follow-up question on this from the audience, and it's a little bit long, but let me read it to you guys. What about the economic exploitation of female athletes via NIL restrictions? Female athletes could make more money via social media endorsements than many male athletes, and because of the lack of pro options, have an even more limited period to capitalize on their athletic ability. Mark, can you speak to that first, and then I'll get your comment, Rick?
Yeah, I mean, this is one that really gets my blood boiling. Because one of the NCAA's defenses against name, image, and likeness is they keep purporting this is going to somehow hurt female athletes. At the same time that they give the women a gymnasium and a weight room that's nowhere on par with the men's. That's simply not true. In fact, some of the athletes who would benefit the most from name, image, and likeness rights would be gymnasts, because the female gymnasts are in their prime at the point in time in which they're in college. When I got asked to testify in California for Nancy Skinner before that state's name, image, and likeness bill, I was one of the 3 people testifying. I was testifying on the antitrust issue. Another one of the people testifying was Haley Hudson, who was a star college volleyball player at Stanford University and is currently a law student at UCLA. She was even able to explain that even from the standpoint of playing a non-revenue sport such as volleyball, there were opportunities that she had to turn down to endorse sunglasses and other products. I think name, image, and likeness is truly the low-hanging fruit because there's theoretical opportunities in the free market for a lot of people to make money, at least small amounts of money. And female athletes that are knowledgeable about this want the opportunity to attempt to do so, probably as much as male athletes do.
Rick, what's your viewpoint on the intersection between NIL and women's sports and women's rights in this? Because we start off with the fact that there isn't a traditional revenue sport devoted to women. And of course, as we've seen in the WNBA, there's a strong argument that the lack of marketing and promotion results in women's basketball not becoming a major revenue sport, but bypassing whether or not the men and the male athletic departments have set up a system where the women aren't going to be revenue producers, to the extent that women athletes have an alternative method to make money. Should that be open to them? And is that a stronger argument for NIL than any of the other ones we've heard?
My only point, I completely agree with everything Mark said. I completely feel that all athletes should have the right to license their NIL to third parties, and that the market can determine what everybody is worth. My only point was that issue has nothing to do with the exploitation that takes place by schools. Okay, giving all athletes the right to license their name, image, and likeness to third parties has nothing to do with exploitation by the schools. That was my only point. So even the question itself tends to lend itself that we should think that, and we need to stop thinking that. We need to recognize that the NIL issue has nothing to do with schools exploiting college athletes.
So is it fair to say that and I'm asking this to both of you all, and this is a central frustration that I have, and it's interesting hearing your words on this, Rick, and your comments you've just made, but it is a misdirection. NIL is a misdirection away from the real money, in my opinion. When you look at the revenue and you look at the fact that when the NCAA went to a business model in the 70s and made athletic departments in Division I self-supporting, it created a system where football and basketball had to support or carry the major load for the cost of operating the athletic department. And the cost of that is huge. And the revenue from football, as you've noted, is huge. And to a lesser extent, men's basketball. And those two sports are the only real revenue producers. And both of those teams are in excess of 50% Black in the Power Five. So the vast majority of the money is earned in the Power Five. So you have 65 universities times 85 players who are earning the majority of the money. And instead of talking, and we're talking billions of dollars per year, and instead of talking about how we redistribute this money to the players in a fair and equitable way, after taking into account that they don't get workman's comp, they don't get health insurance, disability insurance, or life insurance. They don't get taken care of after they graduate, unless by the grace of God, the school chooses to. We're replacing the fundamental equity argument. And when I say we, the NIL group wants to avoid the big money and talk about the narrow money. And the narrow money may emancipate at smaller levels more people, but it doesn't solve the disequity in college sports. Is that a fair way to look at what's going on, Rick?
Oh, absolutely. And I'll take it a step further. Look at the state laws that have been proposed. I was floored that when they came out, starting in California and then into Florida, that these are so-called college athletes' rights advocates who are putting for the first time in law that schools are prohibited from paying players. I mean, there is no law that says that schools are prohibited from paying players. And now we have state law that, or laws that are suggesting that, they're going to be the savior of, college athletes' rights by prohibiting schools from paying players. And, I just, that just more to your point, Rick, in terms of where my perspective is on this. So.
And Mark, to a similar degree, to the extent that the NCAA and the universities have tried to lobby Congress for an antitrust exemption, these again are examples of, if we know there's going to be change, let's try to control it and limit it. When with the free market, if you're, whether you're, Republicans are in favor of a free market. There's no economic argument to limit college athlete rights, are there, Mark?
No good faith argument. Let's remember again, the NCAA is composed of 1,200 member schools, many of them being the largest public schools in the state and many with huge endowments. With the perhaps exception of the National Rifle Association, the educational industry, which includes the NCAA, is the most powerful lobbyist group in this country. And they have been able to infiltrate into a whole host of different bills on the state level to turn what once were really good state bills into things that were a little bit less. And they've been trying to negotiate to give away nil, which is not a right they have the right to control in the first instance, in exchange for some purported antitrust exemption and some purported exemption from athletes being treated as employees, which is completely not justified. But I just want to talk about the California bill for a moment, because I was asked to testify on behalf of the California bill from the perspective that the NCAA would not be able to ban California member schools for complying with the bill. So I know a bit about the history of the bill from where it was proposed to where it ended up. Nancy Skinner proposed the bill. She is a Democrat from Berkeley, and she proposed a bill that was intended to increase the rights of college athletes by preventing the NCAA and its member schools from preventing athletes in California from endorsing products. That was the point of the bill. Now, unfortunately, between the point in time when the bill was proposed and the time that the bill came through, everybody came in with their own interest and their own pork. So the original iteration of the bill did not have this language that colleges can't pay their athletes. And the original version of the bill did not have this 4 years until it went into effect. And the original version of the bill did not have this language about perhaps carving out certain categories. This was added by other folks later on. To me, the original intent of bills that simply will say the NCAA is violating antitrust law in this area by not allowing colleges to license name, image, and likeness, and we in our state cannot be violating antitrust law in that manner, is a good thing. But there are other people that are putting pork into these bills and watering them down or creating an adversarial aspect into them, and that's where the problem lies, at least from my perspective.
Well, but state law is not an effective way to deal with this, because aside from the fact that these laws impose unnecessary restrictions on their ability to license their name, image, and likeness, they don't have any realistic, practical, or even expressed enforcement mechanism. Okay, so who is supposed to enforce these? How does this get enforced? Does the athlete have to sue? Do they have to go hire a lawyer and sue when the basketball program sits a player because they were paid some money in the context of an endorsement? Because that's what will happen. There's no scholarships taken away. These bills are drafted as if, the school in the NCAA is going to take away their scholarship or their grant and aid, to be more appropriate. They don't do that. They sit the player and then they go through the NCAA reinstatement process. Okay, so one, who is enforcing these? Number two, how are you going to get around the institutional control obligation that a school has as a member of the NCAA? Because when that endorsement hits that player or they receive money, the school is going to sit the player. And the reason they're going to do that is because they're going to do the cost benefit analysis. And they're going to say, okay, what are the possible sanctions that could be imposed on us if we don't sit this player? And what is the risk to possibly something happening under state law in the event that somebody pursues something, whoever that is. So, I don't know how these state laws are going to be effective.
Well, Rick, I think you probably know, because we've talked about this, the way I would have loved for this to have been handled. Now, I am just an academic sitting here. I am not DOJ antitrust. If we're up to me, most of these problems would have been resolved by the US DOJ bringing an antitrust suit against the NCAA member schools to enjoin many of their rules. Now, you're shaking your head no, but that is the way. It's a classic 1,200 member restraint. There's a restraint, you break up the restraint. Now,
No. I'm practical, Mark. It's just, that sounds good. It's not happening. It's not going to happen.
back up. Why are you so sure that wouldn't happen? I mean, it hasn't happened for a very long time, but here's the interesting thing. California begins putting pressure on the NCAA. They get a lot of attention. Now, all of a sudden, after the DOJ in our lifetime has not paid any attention to this, now all of a sudden Del Rahim sends the letter to the NCAA warning them that a lot of the restraints are in violation of antitrust law. And now the new Democratic DOJ under Joe Biden has asked for 10 minutes to speak in Alston and take the player's point of view. So whether these bills by the state are good or bad, in your opinion, I think what they're doing is they're pushing the DOJ to do what you never thought they would.
My perspective is that antitrust is not the answer to, it's not going to solve players, their rights. Antitrust has never been effective in helping players, either pro or amateur. It happens the way that players in league sports with league imposed restraints, the way they get their rights is they assert them. Okay. They assert them collectively, whether that's through, a labor organization or whether that's, through some non-labor organization, and, it evolves into one eventually. They have to,
Let me break in here.
they have to assert their economic power. And it's just my personal belief, Mark. I mean, I respect your views and your opinion. I don't view as antitrust as the answer. I don't think anybody's going to save the players. I think players need to save themselves, like we've always seen throughout the course of history.
On that point, because I want to come back to this organizational issue, Rick, but Mark, to the extent of whether or not antitrust is the right theory to be attacking or trying to ensure players' rights, you brought up a point that, the NCAA asked for review in the Supreme Court in the Alston case, and out of the blue, that surprised many people, although it had been building, the Department of Justice and the Federal Trade Commission, who jointly regulate antitrust law in this country, filed an amicus brief in favor of the players, and the Solicitor General asked for 10 minutes, as you noted, the Supreme Court has never turned down, to my knowledge, a request from the Solicitor General to engage in oral argument. And there's every reason to believe that, and since the plaintiff or the defendant players have ceded 10 minutes of their time to the Solicitor General, it's a foregone conclusion that the Solicitor General of the United States will be arguing on behalf of the players in Alston, which I believe dramatically changes the calculus of Alston. It takes every other amicus brief, and there's dozens of them, right off the table. The only thing that matters is plaintiffs, defendants, and DOJ/Solicitor General. And I think the NCAA is going to get killed in Alston because of it. But before that happened, I was extremely worried that the NCAA would be able to influence the court. So quickly, not a long speech, but quickly, do you think that by DOJ and FTC participating on the players' behalf with the Solicitor General, do you think that that will fundamentally change the outcome in Alston?
No, I think it would be 9-0 Alston either way, irrespective of whether the DOJ took their side or didn't. 9-0 Alston. Short enough?
Meaning players win regardless.
Players win regardless, 9-0. The question to me is whether it's a simply affirming of the Ninth Circuit Court of Appeals decision, or if it's even broader. But the NCAA is now arguing this case like it's American Needle. The NFL lost American Needle 9-0.
Okay, so in the O'Bannon case, you have Claudia Wilken dropped. She noted in her opinion that the plaintiff's class counsel had dropped their unjust enrichment claim. And then she dropped a footnote and explained how the universities and the conferences sell the name, image, and likeness of the players to the networks, and the networks don't know they're buying stuff that they don't own. And hey, kind of rudely, I thought, for a federal district court judge, basically and very sublimely said, "Nana, I would have found for you guys if you wouldn't have dropped this claim." So to Rick's point that if you want a legal theory that gets the payers played, unjust enrichment, and he's written on this, is the claim to make. I happen to agree with him. What's your view on that?
I think Rick and I have a little bit of a difference in opinion in terms of the best way to get rights for college athletes. I think we land in the same place, that we know the system needs to be changed. And I think this difference in agreement that Rick and I have is no different from the difference in agreement that leading lawyers for sports associations and academics on behalf of sports associations have had for generations. We see these same debates involving the NFL and NBA reforms over the past 50 years. And that's simply, do we think the labor or quasi-labor route, or do we think the antitrust route is the best way to go? And I think Rick and I come to different points, and I think there are different people that are on both sides of this. I mean, from my perspective, overturning the restraint is still the answer.
My direct question to you, looking at the O'Bannon opinion and what Judge Claudia Wilkins said, she said she would have found for the players on an unjust enrichment claim, and that would have opened up Pandora's box. That would have opened up the money. And because the class counsel didn't want it, because the class was certified on liability but not damages, and because class counsel didn't want to spend the time litigating 40 damage claims for 40 plaintiffs, or whatever the exact number was, they dropped the claim. And I'm asking you, wasn't that the claim to bring in O'Bannon, and wouldn't that have changed the discussion that we're even having now?
I'm not convinced it would. O'Bannon was a complicated disaster of a case, because the O'Bannon case began as a right of publicity case brought by former college athletes related to the use of their likeness on a video game. And by the time the case ended,
And
it became an
t-shirts.
it became an antitrust case involving a class of current college athletes related to arguably the use of their likeness in television. That case changed so many times along the way that it was chaotic. Alston is a smoother case. Now, I don't know what Wilkin meant by that paragraph. All I know is that case changed more from beginning to end, and there were a lot of things missing from it. They needed to have a consumer demand study. The plaintiffs did not have a rebuttal consumer demand study because they were not prepared initially to bring it to antitrust. So there were a lot of problems with that case.
Yes, there were. Switching back to you, Rick, in terms of, and not, I'm not discounting what you just said. I want to get back. No, because I agree with everything you said, Mark, that from the way class counsel for plaintiffs handled that case, there was a change in lead counsel within that law firm during the course of the case. There were 3+ amended complaints that dramatically changed what they were doing. The case changed all around, and they weren't focused on damages, so they didn't have the proofs that I'm a plaintiff's lawyer. I want to win money. From day one, I'm planning what I'm going to tell the jury, and O'Bannon was not handled that way. So I agree with your criticism there, and I believe it's valid, and it was outcome. The outcome was so poor in O'Bannon because the quality of the strategy. Let me rephrase that, because I don't necessarily need to criticize the lawyers here. The lack of a coherent strategy to get to yes wasn't there, and you set that out perfectly. What I want to get back to Rick about, and I'll come back to you on this, is where does self-help come in here, Rick? And you talked about, do the state or do the state legislatures or Congress or the Supreme Court, do they have to tell anyone that the players have fundamental human rights to earn money? Everybody has an intrinsic human right to earn money. And when are these players, and I believe you believe this to be true, but when I think of the example of Mizzou football, and they stood up not for themselves, but for civil rights on campus, but that's a concrete example of a football team coming together saying, we're going to do something. And they got the administration removed. Unfortunately, they got an administration that wasn't much different in replacement. But Rick, do you think that apart from all, we're all lawyers, and you guys are law professors, so we love talking about law, but at the end of the day, isn't this really a self-help problem?
Yes, I believe it is. Like everything, like anything in life, really. Anybody, there are many people who would say, and I completely disagree with them, because I've heard it numerous times. There are many people who say that college athletes are not capable of, or football specifically, really need to be talking about Power 5 football players in this context, Rick, because it really doesn't make a whole lot of sense for the athletes in the other sports.
Let's do that. Let's limit the self-help to the biggest revenue and the smallest groups. So if we want to capture the most money, it's Power 5 football. Right. And what is your answer to how Power 5 football players get what they're owed?
Well, the first thing they need to do is they need to get things, think like business people, and they are capable of doing that. Okay. Anyone who says that they're not capable of forming some sort of an association and asserting their economic power, I completely disagree with them. They are fully capable of doing it. There are many people who give excuses as to why it can't be done. And they'll throw every excuse against the wall as to why, they don't want to see this happen by Power 5 conference football players. And to be more specific, I think you have to look at this on a conference by conference individual basis. If you look at the economics of the way the industry operates, what makes sense would be multi-employer bargaining unit at the individual conference level. Okay, within the Power Five, that just works for lots of reasons. Economically, the way they share revenue within the conference, the way geographically it works in terms of, competition.
We have a question from the audience, Rick, that feeds right into what you're talking about.
Very complicated. I could talk for hours.
No, but let me read this to you because I think it fits into what you're saying, and also, but it almost reverse somersaults back into regulation. But let me read you the question and get your reaction on this from the audience. How much do the panelists believe the efforts by college athletes, specifically football players at Northwestern University to unionize, if approved by the NLRB in 2015, would have advanced the NIL question? And within that, the question doesn't point out that the NLR, the district, you would know the name of this because you have the opinion, but the district found that the players were employees.
Region 13.
Region 13. So there was a finding by the agency that football players were employees, and then I'm not a labor lawyer, but my understanding is that the NLRB refused to exercise jurisdiction because Northwestern was the only private employer in the Big Ten. But if the NLRB had ruled on this and found that the players had the right to unionize and were employees and all this other stuff, would that have changed your, and by your, I'm referring to you, Rick, what you said about self-help and self-organization, would that have weakened their movement or strengthened their movement or misdirected their movement?
Yeah, no, first of all, we talk about players doing some sort of, as you refer to it, as self-help. The question is, what do they want? Okay, so one of the biggest problems I have is that everybody wants to tell football players, for example, in the Power Five, what rights they should have and shouldn't have. The question is, what do they want? Okay, and that's a question that I don't really, I'm not going to give you the answer because it's not my place. But that's what happens when you use self-help. They have to be the ones that do it, not somebody else, and somebody else determining what their rights should be. That's the first thing I want to say. Second thing I want to say about this, the Northwestern case, some clarification here. Look, the jurisdiction issue, the NLRB, that's the right call, okay, from a practical standpoint, because they didn't have jurisdiction over public universities because the NLRA doesn't give the NLRB jurisdiction. Their hands were tied. Practically speaking, it wouldn't make sense to certify a team bargaining unit. Okay, it wouldn't work. It doesn't work. It wouldn't work in professional sports leagues. It wouldn't work here. You need uniformity. You need all of the players within the conference and all of the schools within the conference as a multi-employer bargaining unit. So the second thing I want to say is that the NLRB didn't overturn or reject Peter Orr's conclusion that they are employees by definition under the common law test. Okay, so let's just make that clear. They are employees.
Peter Orr is the regional director of the NLRB.
Right, the regional director, who you referred to, said that they are employees under the NLRA, right? They meet the common law test. They do. They are employees. And so the issue is that they can't, and this dives into Mark's antitrust stuff, that they can't individually market themselves, and get wages because of the NCAA rules that restrain trade. But from a labor standpoint, purely labor standpoint, one way to help this issue for players would be if the NLRB had jurisdiction over public universities in the context of intercollegiate athletics. So, I mean, but that we're kind of going off on a tangent here, I think, but.
Well, not really, because all of these things, tangential or not, come out. The reason we're talking about player comp or NILs is because there is public concern that's raised enough people's heads to listen, that people have come to the conclusion, I think, majority-wise, that to some degree players should be able to have access to earn money, and how we call it, whether we call it NIL, whether we call it actual employee status comp, whether we call it benefits, whatever it is, I think people are coming around to that conclusion that somehow the players deserve something, and at least one of the concerns I've had, and we talked about this earlier, was that NIL can misdirect the focus, because NIL is the pennies left on the table versus the real comp that the schools are earning on behalf of football and secondarily basketball players. And then we've had the side discussion with you all that for the non-revenue sports, NIL possibly presents an opportunity on an individual basis, not on a universal basis, but allows some athletes in non-revenue sports who have some level of fame or prominence to earn money that they otherwise wouldn't be able to. And as the market, right now you can look at an individual. Mark testified, I believe, with a volleyball player in California. So you could look at volleyball, and you could, maybe she was the star, national star that could sell Coppertone sunscreen. But once the NIL market opens up, and there's 500,000 plus or minus college athletes in any given year, the NIL market is going to become saturated. There are going to be very few people who are going to be able to earn any appreciable amount of money. But until it opens up, you can take an example and say this person's worth X in the NIL market only because there is no NIL market. But when that many people all of a sudden can market it, the average price is going to go down. But still, as Mark mentioned at the beginning, and as well, the poverty levels for so many college athletes is scary. I mean, we're talking about a huge percentage of Pell Grants, people who have, they don't have the money to go out and get a pizza. They don't have the money to go out and go on a date. They can't buy a new pair of blue jeans. The economic circumstance of college athletes is not great in the Power Five, especially. And as you go down to Division III, they're no different than everybody else. So while Mark has pointed out correctly that the NCAA is a large apparatus with a lot of political control, there's a tremendous difference between D1 versus D2 and D3. And I'll ask you this, but I think you all would agree that D2 and D3 are not legitimately part of the discussion of player comp and NIL because nobody cares. Would that be fair?
I would say no. I mean, in terms of NIL, the NIL is simply a restraint by member colleges that aren't necessary. I agree, Richard, I agree with you, and I agree with Rick that we're obscuring the broader issue if we focus on NIL and NIL alone. But I do believe NIL provides opportunities, and I do think the restraint on NIL on any college athlete is inappropriate, both as a restraint of trade and as a restriction of liberty.
And I completely agree with you on that. But do you think that and I think we talked about this at the beginning, I think you agree that to some degree the NIL discussion misdirects our focus from the big pot of money.
Yeah, I would agree with that. I agree that there are several bundles of rights that college athletes are being deprived of by concerted agreements amongst the member schools. And NIL is just one of them, and probably not the biggest one. But I do still think NIL in its own right is important. And it still is a restraint when you restrain it. That needs to be corrected.
To both of you all, Rick, you first. How much does the NSA's propaganda come into this? We're seeing it ramp up again because of the Alston case coming up for hearing before the U.S. Supreme Court. What's your opinion as to whether or not there is coordinated propaganda coming, not just from the NSA, but from its members who, as Mark pointed out, besides the NRA and possibly the AARP, there's certainly, universities are certainly within the top 5 lobbying groups in the country, and every congressman has a university in his or her district. So the ability for the NCAA to get its message to congresspeople is probably better than any other lobbying group because of the economic influence of a university in the local economy. Did I ask a question?
No, you did not. You asked about, you said.
Okay, so my question to you, Rick, is, do you see a ramp up in propaganda by the NCAA and its members on NIL rights, compensation rights? And if you do see that,
I don't see it any different than it always has been. I mean, we've always had these commercials that say, during March Madness that, they're over 400,000. The number keeps getting bigger, I think. They're over 380,000. Now they're over 400,000 college athletes who are going to go pro in something other than sports. Yeah, I don't know, Rick. I guess I don't see the propaganda, so to speak.
So I'd ask Mark about ringers, and I'd asked Mark a question a while back about ringers and whether or not you could look at a college team's graduation rate and presume that a team that graduates less than half of its players, that those teams are essentially ringers. Do you have an opinion as to whether or not when you go, and this is more true in basketball than football, but as you look at the team graduation rates and they fall beneath 50%, those people presumptively don't have a good faith intention to be college students. They have an intention to play college sports, which would make them ringers. Do you agree with that, or what's your view on that? Rick Karcher.
Yeah, I don't know, using the term ringers. Yeah, no, I don't really know how to answer that, Rick. I think you're getting into something that raises different sorts of issues and problems than.
Well, it kind of flows from the question we had from the audience about whether NIL was a way for boosters to bypass the restrictions. And so if we're going to talk about, the NCAA has all these rules to limit and theories as to why we should limit or college athlete rights. And so I guess I want to know.
Well, you mean as a way to bypass anything? The only reason they wouldn't be bypassing anything if they're allowed to pay players, right, for their endorsements or for their likeness. I mean, right, but they can't right now. So if they did, right, right now, then we have violations by this, the school's going to have to.
Yeah, but my question is we as outsiders look into this system,
Mhm.
if they have a rule that you can't, cheat the system because these are college students, and if in fact they aren't graduating more than half of, let's say, a basketball team, are they in fact really college students?
Rick,
Richard,
Rick, I don't get into this sort of and I'm sorry, I just don't get into this kind of debate. They're college students, and what they're also employees, but I guess you're getting into sort of a different question, and you're getting into the academic side of it, and
We have a question from the audience
Yeah, go
that is a follow-up to you, Rick, and then I'll ask Mark to weigh in on this. And it's interesting how it's posed, so I'll read it to you. Is it not part of the problem to tell the students who this very panel of white men, which we are, have acknowledged come from less privileged backgrounds to conjure up quote unquote self-help? In other words, are we in trying to be practical, are we being dismissive that these people may need, they're young men, 18 to 22-year-olds. Is it fair to say, go help yourself, not our problem?
It's a great question. I think that they are adults, and I do believe that they're capable. Many of these students who are playing for football teams on Power 5 programs are even, they're in graduate school. They're getting graduate degrees. Okay. The issue is not, in my view, that issue as much as it is that they are fearful. And the question is whether their fear is, how do I want to put it? Whether it's something that, they can overcome, right? It's really boils down to fear. They are told by too many people in society right now that you can't do that because you will face consequences. Okay? You will face consequences from your coach. You will face consequences from whoever. Okay. If they can overcome that, okay, because in any organizational effort, any sort of what we would call some sort of a unionized effort, whether they're certified labor union or under the NLRA, or they're just an unincorporated association that is able to exercise its economic power. In any situation like that, people are going to have fear and backlash. And, so to the extent they can overcome that, and I'm going to say one more thing, it's the economic power that they need to realize. These people are unique people from the standpoint of their skills. They're not like anybody else in the world. They're not replaceable. Okay, they are highly valuable to these schools. Okay? These are not. We're not talking about Chick-fil-A workers who are wanting to get paid more money. Okay, we're talking about a select group of people who are not replaceable and are in a situation where, if they were to do that, okay, the conference, if they did that, is big time pressed against the wall. Okay.
All right.
Yeah.
So what the implicit question was, are the three white guys on the panel
I know, I heard it.
just shrugging their shoulders saying, up to them. But what I'm hearing from you, Rick, and tell me if you agree with this, Mark, is that the message that's coming that premises your theories is that it's a message of empowerment to a majority Black football team in a Power 5 conference, that you all have powers that everyone's saying you don't, but you do. And so instead of viewing it as a bunch of white guys saying we don't care, the actual message that you're giving is, I care a lot, but what I want you to understand as young Black men, you have the power to change this, not me. You and only you can walk off the field and say you're not playing. And until you guys make that decision, nobody else can help you.
That's not my message. That's not my message.
Okay. Is that kind of your message, Rick?
Yeah, I mean, I don't, you know, there can always be people to try to help them, whether it's, you know, Congress or the NCAA decides to change their rules in certain respects. I'm just saying that, you know, the way you make change, if you want to change it, is, or here, I'll put it a little differently. Back to my point about, you know, antitrust law and how I was adamant that antitrust law is not their savior. Rick,
guys, we got 5 minutes left, so I need you to wrap this up, Rick. I need to get to Mark, and then we've got to do some concluding marks.
All right. As long as the players keep showing up and playing, okay, nobody's coming to their, going to be their savior, not the courts, okay, not the NCAA, okay. As long as they keep showing up and playing and making schools money, I don't see a whole lot changing by you know, through the courts and antitrust or the NCAA. So there's my
Mark. What's you don't share something I said. Clarify your opinion on this, and then we need to give each of you guys a minute to wrap up and let me conclude the panel.
I disagree with Rick Karcher with respect to the Northwestern decision. I think the Northwestern University football players should have been allowed to unionize. The Labor Relations Act of 1935 gives members of unions the right to bargain over hours, wages, and working conditions, as well as the right in certain circumstances to strike. These rights were created because if you are not a member of a union and protected this way, you're going to be afraid to stand up for things. We have a chicken and the egg problem here. Until we give college athletes the right to unionize, I don't think we could expect them to engage in behaviors like strikes. And we have a prisoner's dilemma problem here, that until the athletes are able to organize all together, they're going to be feared, they're going to be the one, and they're going to be punished. I still think that antitrust and labor law are the right remedy to go. I don't think we could expect athletes without legal protections to necessarily stand up for themselves. I applaud them to do so. I believe they should lead the strategy. I believe it's their movement, not ours. But until we do a better job of protecting them under labor law and under antitrust law, I don't think we could blame the athletes for not organizing a workout. I think each individual one is reasonably afraid to do so, and we need to have a way to allow them to have collective action.
So Mark, in less than a minute, if you were able to sit down with President Biden and you had 45 seconds to tell him what to do on this issue, which may in fact be true, what would you tell him?
DOJ, antitrust case, break up the NCAA like you broke up the Baby Bells, let each conference work collectively, make the conferences compete, and strike down the restraints on trade of when they act collectively. That's the first step towards change.
Rick, if you could sit down with President Biden and you had 45 seconds to talk to him, what would you tell him on this issue?
Convince Congress to amend the NLRA to allow players to collectively bargain and give the NLRB jurisdiction over public universities so that it can actually happen, practically speaking, and in an effective way, as opposed to, as Mark said, giving one team and one conference the ability to form a single team bargaining unit, because that's not good, won't work for the industry. So
we've got less than 2 minutes left for our panel. I want to thank both of you guys for an incredible discussion. A lot of agreement on things, a lot of disagreement on things, and a lot of interesting comments that have made me think quite a bit. As I look to these discussions with various academics, more than practitioner lawyers like myself, you end up getting a lot more theory and a lot more thinking going on because you guys are professors, and I find that very stimulating. I'll end the panel with this thought, and turn it back to Richard Southall and Kim Boone, which is there's, in my mind, to synthesize some of both of your comments, if we amended the NLRA to include students and parents at every university in this country, and superseded state law on that applies to any public workers for state universities, the problem with increasing tuition in this country, unlike in Europe, is we don't have student unions. We don't have parents able to organize on these prices. And the greater unionization effort by 2 million people going to universities every year or thereabouts align with the rights of the players. So to the extent that people become more interested in the players, parents who are having to pay these increasing tuition bills, if they could negotiate like the AARP negotiates for prices, college prices wouldn't be going up like they are. And so I think there's a way to market college athlete rights to a larger audience by expanding who gets the right to organize. And it really should be the entire basket of students and their parents, whether they play sports or not. On that note, we're done. I'm being told I gotta turn all of our videos off. Mark, it's wonderful to see you again. It's been, I think the last time was the CARE conference.
That's right.
And Rick, wonderful to see you again. You're one of my favorite people, and both of you all, thank you for thinking seriously about these issues, and for your very smart commentary. It's greatly appreciated. Have a great day, guys.
Take care.
Thanks.
Bye.
Well, I want to thank every one of the panelists for a great and thoughtful conversation. We will see you in a few minutes for our second panel, and I'll turn it back to Kim now.